Oh, yeah? Okay.
Yes.
This case, D446900, the Feindel case. Parties are present. Okay. We were sheet. Here on the 16th, we gave Mr. Feindel a little bit more time to put his financial stuff together. And I don't even know, I'll be honest with you, Mr. Feindel, what to even call this or what order it's in. Did we not talk about maybe some spreadsheets or things like that?
The first sheet should have been a spreadsheet printout showing earned versus
Are you talking
receipts.
this?
I believe so.
Marshall, Bill. Did you receive a spreadsheet, Ms. Feindel?
I did. I received the file, yes.
I'm talking about any sort of like Excel spreadsheet showing. You know what a spreadsheet is, right?
Yes, I do. No,
I'm assuming a computer person knows what a spreadsheet is. Is that different?
That's correct.
Well, that wasn't even in there. Did you get this working? This was just given to me.
Yes, I did get this. Yes.
Well, Mr. Feindel, let me. We'll make us. I can assure you a very clear record in case this goes anywhere past today. But I'll. If this is what you're submitting, is this spreadsheet and these particular documents, and I'll firm. Go ahead, Marshall. Make sure we're not missing anything.
Yeah, it's got bank statements, spreadsheet, and receipts. Bank statements and the receipts match up, and that's what's on the spreadsheet. The combination of the two totaled up.
All right, since he's plaintiff, Madam Clerk, each, I guess, staple packet will 1, 2, 3, 4, and 5. Is that how many staple packets you had total? 5?
I have 4. I have 4 here.
Marshall Bill, take, well, let Blanca mark them first.
Your Honor, I think one of them is probably 2. Here, it's just stapled
There's this,
together.
right? That's right there. I see that. You have this.
Yes.
Okay. You have this.
Yes.
You have this.
I do.
You have that.
I do. It was just stapled together.
Okay.
I
She's got it all.
apologize.
Okay. Mr. Feindel, a phone call was also placed to you earlier today wherein we asked for you to submit your tax return. First of all, you indicated you're not even sure you're going to file by the 15th. Is that correct?
I'm going to attempt to, but that depends on if I have all my 1099s in a row.
That's an interesting statement. All your 1099s in a row?
Correct.
Because attached to your
Was it
financial
1099?
disclosure
That is correct.
is one
That is correct.
1099.
That is correct. I have yet to file for 2012 because I was rejected for that. I have prior returns that are still in limbo.
No, I find it curious. I'm asking you.
Okay.
Because again, let's be very candid. Because your defense or your reason for me to, she's filed an order to show you or hold you in contempt. I've changed custody already based on your noncompliance with the court order for the parenting coordinator. Correct? So we're kind of here for your explanation as to why you couldn't afford a parenting coordinator. So it really comes down to your income. So I find it very curious that you say 1099s plural, but yet you attached your financial disclosure form, what you filed in January, just one 1099.
That's correct.
So you had multiple 1099s in 2000?
I have multiple years that I need to file taxes.
I'm asking for 2015.
And in talking to the clerk on the phone, I told him I hadn't filed 2015. He said,
I am asking how many 1099s you have for the year 2015.
I believe I will have one. I believe will have one. Last year I had, I think, one. And the year prior to that, I had two. It depends on what's deferred. I'm self-employed all the way through. I brought 2014 because the clerk said that's what I should bring.
Well, that's because that's the only thing you have. I mean, something is better than nothing. What? How much?
It's not a. Anyway, I brought 2015
20 what?
or 2014 return.
And again, to reiterate, because this may come back in case you end up perjuring yourself if I give her the ability, and I will, to go ahead and subpoena the IRS. You're saying you didn't receive any other 1099s in the year 2015 except for the one from Byron Solutions.
Bryden Solutions, and those are the ones to date.
You keep saying ones. There's only one 1099 that they send you at the end of the year.
I have multiple tax forms in limbo. You had her correct. The 2014 filing, I was able to claim my child. I got this one way after the fact. The 2012 is still up in the air. The 2013 I haven't done yet because the 2012 is in limbo.
In 2015, you only got one 1099.
So far, correct.
Are you expecting any more? Is someone have not sent you anything? Because 1099s are usually due, my understanding, and I'm not a tax professional, but I at least know 1099s are due by January 31st.
Respectfully, I'm not either. I'm.
Did you work for anybody other than Bryden Solutions?
No, I did not.
So they're the only ones that paid you?
That's correct, unless there's something deferred from a year prior.
I don't know what that means. You would receive the 1099 if it was for that year. Marcia Bill, go ahead and show her the 2014.
It has my daughter's social securities on it.
It's not a public exhibit.
Okay.
No. So where are your 1099s for 2014?
Submitted.
I'm sorry?
I submitted that with my financial disclosure form, the last hearing or the one prior.
So you didn't keep a copy for your own tax return?
I don't have it presently in my backpack, but let me look. Let me see if I have one.
Wouldn't it be attached to your whole income tax return that you file with the IRS and just simply be copied like everything else?
I have it. I have it. for 2014. Is that correct? The 2015 1099 is attached to my prior financial disclosure. The 2014 1099 is here. I thought it was part of the TurboTax return.
Marshall, let me see what that says. Go ahead and show it to Ms. Feindel if she wants to see it. Is this a copy for the court?
Sure.
Okay, Madam Clerk, I am just going to stick this 1099, or is this your only copy?
I honestly don't know.
We'll make a copy to be safe. Let's make a copy for each.
Number 6 in his exhibit.
Well, hold on.
I believe there is a copy of that in with the TurboTax stuff. I'm sorry, I just don't know.
There is not. That's what
Okay.
I'm saying. Or else I
All
wouldn't
right.
ask you
Yeah,
for it.
I got that call when I was driving over, and I went back and printed those.
So it for certain remains confidential. I'm not going to go through there and make sure there's any for Social Security numbers, et cetera, et cetera. I'm just simply going to paper clip so the 1099 is attached. I will note for the record that in 2014, first of all, this is Peaceful Computing LLC.
Correct.
Showing $28,680. And I guess what I also don't understand is on your recently filed FDF, filed January 26, 2016, you indicate a data hire at Bryan Solutions. And in fact, the 1099 attached to that is from Brighton Solutions.
Correct.
Right. So where's 1099s for Brighton Solutions for 2014?
I wasn't with Brighton Solutions in 2014. It is the same company. The name has changed. It's been bought out. But I'm working with the same people. If she subpoenas again, as she already has with Peaceful, she'll get the same guardian of records and the same stuff back. I apologize for any confusion, but we are the same people.
Okay.
That's the way it was issued to me when they changed it. And that one should show 37K, the 2015 one, correct, on my FDF?
I'm sorry?
The 2015 1099 should show like 37K, something to that effect.
$36,421, and we divided that by 12 months to get your current child support amount. I guess we'll start by Mr. Feindel. The financial documents that you're submitting to the court actually show that your income, since you started this action back in 2012, has actually more than doubled. So we will go ahead and file. First of all, Madam Clerk, let's make. For the court's record, we will file your 2012 FDF, your tax return for 2014, and your current financial disclosure form filed in 2016. That will be Courts Exhibit 1, Courts Exhibit 2, and Courts Exhibit 3. So your income actually is more than doubled.
It was substantially higher, and I believe in
Right.
12, and then it was down in 13, and it's up in 14. That's correct.
Right. It's gone up a bit from 14 even to 15.
Yes, correct.
Right. So you're the one coming to court saying, I can't afford this court, I can't afford to abide by this court orders because I can't afford it. Let me also go back, since we're building a record here. Let me go ahead and admit as, let me see, can I have the Mortallero report? I'm sorry, I got it, never mind. I'm going to admit as Courts Exhibit 4. You remember doing the assessment with Dr. Mortallero
Yes.
back in 2012? I don't know if you still have a copy of that.
I could use one.
On page 3 of that, I'll read into the record. It says, and the court ended up incorporating that, in this particular case, there must, quote, must be appointed to help these contentious parents translate into an observable behavior a special master parenting coordinator. That's where we got the idea from after the assessment. Okay, then it was made into a court order. Do you recall that?
There was 3 years in the interim.
There was.
Okay.
I delayed it. I gave you guys the benefit of the doubt, tried to do the UNLV stuff. I even said if anything else gets filed, I'm going to fire a parenting coordinator. So I gave the benefit of the doubt. Right? Then you filed a motion in, we heard it on July 6, 2015. You were expressing your problems with Ms. Pickard. And again, we, at your request, switched it to Ms. Schwartz. Nothing indicating that you couldn't afford it. Again, this was in 2015. It was indicated because you were the one. You got to let me back up a little. When the parenting coordinator was first ordered on February 18th of 2014, each party it was going to be split,
Correct.
right? You're the one who asked for the new parenting coordinator, and I informed you that's fine. If you want to do that, then you're going to be able to front the costs. You made a conscientious decision to go ahead and do that, or else it would be split as of now. If we had stayed with the same parenting coordinator, you decided to do that. So we did. We assigned a new parenting coordinator. You were to bear the 100% of the cost for them to get up to speed, and then it was to be shared again. Then, when Ms. Schwartz wasn't taking cases on, it was just simply transferred to Ms. Roberts. And then you decide you don't want to do it anymore.
Made a payment to Ms. Roberts, hoping that would be, the receipt is attached to my motion prior.
When?
2-3 hearings ago. Hang on, I'm finding it.
Attorney Amanda Roberts?
Amanda,
the
there's another
parenting
Amanda
coordinator?
involved. Yes, correct. The receipt was attached to my motion 2 hearings ago. Here it is. I gave her a payment of $500 with the expectation that we could proceed, and she proceeded to bill $300 for 4 emails.
First of all, this doesn't have a file stamp on it.
That's just my copy, but it should have been filed with the original one.
I remember reading this. I know it's been filed. Yeah, but what he's referring to is his opposition that was filed on the 21st. Remember saying that? It's still you gave her $500 and decided you can't afford it or don't want to do it anymore.
She didn't. The expectation was she would write a letter to court stating she'd been engaged. That's what I understood. Otherwise, I was facing a contempt. I couldn't swing an attorney after shelling out that.
I don't understand what you're saying.
I don't currently have any credit. I currently am going paycheck to paycheck. I'm definitely in a bind. So my thinking.
Let's find out. We would not be in this situation but for the fact that you're the one who requested the change of the parenting coordinator. All right? Ms. Roberts apparently has come up with the amount of $3,000. We changed from someone else. I told you when you wanted the request. If you want the request, I'll grant it, but you're going to pay 100% of the cost for them to come up to speed.
Respectfully, I understood when you
That
said
was quite some time ago.
the cost of transition to me meant a couple hours. I didn't understand it to mean.
And
full
again,
retainer.
your paychecks, if that's your defense, don't show that. They show that you're actually making a lot more than even when we appointed a parenting coordinator.
That is correct.
Right.
It's entirely. All the receipts are there. That's what I'm spending it on. I still have
Life
all
is
kinds
choices.
of debts that I have to pay back.
Okay.
All right, my
record-
bank account's been garnished.
The record will be there. Here's the other thing. I've told you before, this is a case where it was ordered that there be a parenting coordinator. I delayed for quite some time. This is not the first time that you've really technically been in contempt of court, in that there was a time before when I read through the history of the case. Remember when you wouldn't sign up for Our Family Wizard and we had to go through all that nonsense? Do you remember that?
I recall respectfully you allowed us to draft a release. They refused to sign the release.
And then
Subsequently, you ordered it
I did.
despite that, and I have signed in.
So as of in 2013, I had ordered it before then. I'd actually ordered it back in December of 2011. By October of 2013, you had still not enrolled in it. And so I had indicated that I would actually contemplate holding you in contempt if you did not file and enroll within 1 week.
And at that point, I did enroll.
I understand that.
Okay.
But it took to getting to that point. You're missing, I guess, the point of today's proceeding, that we kind of have a history here. And guess what I also have for this year? Because we have third-party access. When you sign that to it, we have third-party access to it. I have the most current Our Family Wizard stuff. Right? How many emails have you had in the last couple months or he's not returned?
4 or 5.
Several, right?
Yeah.
Right?
Sorry.
What were they? What was the inquiry over?
You tell me you're on Our Family Wizard. You should be checking it. You get a message. You get an alert when you get a message coming in. Correct?
I see them when I log in, but
Right.
there was a request to ask about phone calls. I didn't have any complaint with phone calls. I mean, there's basically if stuff doesn't need responding to. I'm going off Margaret Picker's advice that less communication is less conflict.
You know what? You mean Margaret Pickard that you wanted to fire?
I want to fire her. It was running up way more.
All right.
None of that was going.
Mr.
to
Feindel, again, it was recommended from the start, okay? You made the decision. I told you, I gave you the option. Oh, that's fine. I'll give you your parenting coordinator. You're going to pay them to get up to speed from the old one. Miss Roberts apparently came up with a figure of $3,000. You're the one that says, no, not only can I cannot afford it, I don't even think I need or want a parenting coordinator anymore. That's not an issue in this case. This case from the forefront has been determined that a parenting coordinator should have been assigned from the very forefront. And then the multiple proceedings subsequent to that are only further indication. And I finally followed Dr. Mortalero's, which I should have followed from the outset. Absolutely should have. Your defense about can't afford it absolutely flies in the face of it. Shows that you're making a lot more than you did back when it was ordered. And you're the one who requested it. You're the one who requested it. And again, we'll go ahead and, for a clear record, I don't know what we're up to, Madam Clerk. You're still non-compliant. If anybody ever reviews the underlying record, it'll show that the last time you even cared to respond to her was back on February 3rd. Before that, January 20th. She's been sending you messages on April 6th, March 26th, March 11th, February 26th, February 18th. February 12th, all with no response. That's why we need a parenting coordinator. That will be, hers will be whatever we're up to,
Well,
and they'll be confidentials.
defendants were just.
No, these are courts.
Okay, that would be number 5.
Well, hers and then his.
Okay, 5 and 6.
So I don't know, whatever else you want to submit for today, Mr. Feindel. Because if your defense is you can't afford it, the proof that you submitted is absolutely converse to what your pleadings with this court. You want my honest opinion? I absolutely believe that you're probably making more than you're claiming. It doesn't matter to me, because what you're filing with the court shows you're making way more than you did when the parenting coordinator was even ordered.
Correct. When during the course of the parenting coordinator, again, my bank account was garnished. I've not managed to keep up with a lot of things. No credit at this point. I cannot spin up 3K.
Hey, listen,
If
all
you-
of
you
all of
gave
the
me-
all of your proof of your financial stuff is filed with the court. It's now a record with the court. Someone wants to review it. They want to sift through it, see if that's true or not. But by your own admission, even if that's the only, I still can't get a clear answer as to whether that's going to be your only 1099 for this year. I don't know how far you want to push it for, perjury and contempt or anything else, but I'll give you 30 days of discovery if you want to subpoena his IRS records. That'll be up to you. And I can assure you, if you made any blatant misrepresentations on your financial stuff, I will incarcerate you. But as far as your basis and reason for the parenting coordinator, again, your non-action with the Our Family Wizard, pretty clear to this court. The most recent, just this year, your non-response to her is reason enough. Reason why we need a parenting coordinator in this case.
Prior to January, how many did you see from me?
I didn't need to go past. Why would I have to go past January? I didn't need to go past January. That's all I asked my law clerk to pull.
How many? And then come February, there weren't any because the child's been at mom's.
I read off the record, Mr. She's been trying to get a hold of you and pass messages along with no response from you.
Address those tonight.
It won't make it into the record. Let me just let you know that. It's a little belated. So
I'm sorry. I thought we were discussing the financials today. I didn't know that was on the.
listen, it all kind of snowballs into one thing. Are we not clear on what it is? You allege that you can't afford a parenting coordinator, and I've said that if you want to have joint physical custody, a parenting coordinator is necessary. So did Dr. Mortallero. That was the foundational report in your case. Okay? I even gave you the chance of the new parenting coordinator. Absolutely did. So go right ahead. You show that you even make and earn more money at that time from when you asked for that change, because I told you you'll be 100% responsible for it. And then a few months later, not only do you not want to pay that, you don't want a parenting coordinator at all. And I said, that's fine. If you're not going to have a parenting coordinator, then I'll have to give her primary physical custody. And that's where we stand. And time has lapsed. So if there's anything else you want to put on the record, go right ahead.
How am I to proceed?
I don't know what that means. How are you to proceed?
I'm not sure what I mean, I guess you're not happy with the financial records that I provided, or?
I'm not saying whether I'm happy or not. They're submitted. They're absolutely submitted. You earn more by your own admission, more than when you asked to switch for the parenting coordinator. You earn more.
Correct. I earn about the same.
According to your 2014 tax return.
And in 15 I earned more. And
Right.
in 13 I earned more. In 12 I earned a pittance.
We were talking about last
there's a
year's when
great
the changes were.
variety of ups and downs in it.
Is there anything else you want to put on the record, Mr. Feindel? Again, I know, because we get this argument a lot. You're punishing me because of this, that, and the other. First of all,
I don't
even
think you're punishing me. No.
if you had brought in proof that you were making less, which you didn't, you actually brought in proof that you were making more. Ironically, it feels like a punishment, but it's not a punishment. This is simply a case that is so highly litigious, has been since it was outsourced back in 2012, that a parenting coordinator was necessary. Due to the finance at that time, I put it off and put it off and put it off as long as I could, and then I assigned a parenting coordinator. I'm reiterating history probably for the third time. I promise I won't again. And then I gave you the parenting coordinator. You didn't like the parenting coordinator. I said, I'll switch you parenting coordinators, but you're going to pay 100% of the cost of the new parenting coordinator to get up to speed. You said, okay. You even started earning more money. You didn't pay it. Not only do you not want the new parenting coordinator, you don't want to pay it.
Respectfully, I did pay it.
You did not.
You have the receipt.
You did not. You paid a portion of it.
Correct, and I would have continued had she relieved me of the contempt
I don't know what that
charge.
means. All I know is she's still not she's not acting as your
She hasn't
parenting coordinator.
acknowledged that.
Right.
Correct.
Because you haven't paid her retainer. Anything else?
Not that I know of.
May I say something?
Sure.
I'm a little unclear on where we're standing as of right now as far as the continued custody goes. Can we...
No, I guess that's what, at this juncture, I modified custody due to the fact that you did not have a parenting coordinator and due to the fact that he would not pay for that. Correct? And you'll have to remind me when that was ordered. Approximately.
When the custody was changed?
Yes.
Just right out of my head. It would have been in February.
For some reason, I thought it was longer than that.
It might have, well,
No, you're right. It was in a minute. It was in a minute order dated February 4th of 2016. So as of right now, to answer your question, for some reason I had thought more time had lapsed. I'm not going to sit here with the calculator. You might, Mr. Feindel, go home and whip out your calculator. And, I mean, I would if I were you, because it's only been a little over 2 months since that minute order was issued. But if you can't, I will go back to the normal visitation as soon as I get a letter confirming from Ms. Roberts that you have retained her. That's what the order is. But if you continue and let that lapse pursuant to Rivero, and you're not able to get 146 days after that change on February 1st, then she will have de facto primary physical custody. The minute you pay her, and if it hasn't de facto changed to her having primary physical custody, it'll revert back to primary physical custody. I will sign a wage assignment if you want to give it to me. You know where. You apparently know where. Whatever you need to do, you can turn it over to the DA's office. You can submit a wage assignment. We're not here for his. I'll note that for the record, though. Why haven't you paid her child support?
I paid it in court on the 16th, last hearing.
I'm sorry.
Marshall relayed it to her in court at the hearing. I relayed it to her on the 16th.
We handed her.
Well, technically, he's not late till after the end of the month.
Okay.
Yeah, but
I
there's no
apologize.
due
I
date.
just-
He has until the 31st,
Okay, I wasn't sure what.
and then
the
it's
dates
not
were
late.
gonna be. Okay. Thanks.
So I don't know what that magical date is. I really don't. But let's say, for instance, guesstimate, I would probably say about 3 to 4 months. I'm guessing. This is just me because I'm poor at math anyway. But if he doesn't do anything in the next 3 to 4 months, I think there comes a point where he's probably not going to be able to get his 146 days under the current schedule, and then you would revert to you de facto having primary physical custody. And then you could submit an ex parte order to that effect, because if I have not received confirmation from Mr. Roberts that she's been retained and paid the $3,000, if he does that within the next, let's say, 2 months, by my own, or I have to stick by my own order, it will revert back to joint physical custody as soon as she's retained. So he's got a little squeeze going on here. If he doesn't meet that time frame, then you're going to get it under Rivero 2, which is a de facto situation. Due to his noncompliance, I will go ahead and find that he is technically in contempt. You don't have an attorney. I'm not going to throw him in jail. Was there anything else you were really asking for?
My main concern is our daughter's well-being. I was more concerned about the custody arrangement.
Well,
If he doesn't have the money, I'm not going to ask for more. But
that's child support enforcement's up to you.
okay, and
I will go ahead and make the finding, though, due to his noncompliance.
is there? Could we maybe meet and see if we could come up with some kind of agreement or stipulation? Is that something we could do?
Permanent one? Listen, right now that's going to be the order. Right now you have primary physical custody with him paying, but again it will revert back to joint physical custody. If you want to talk to him and you want to change it,
Sure. Could we? If you would agree.
it's up to you. Mr. Feindel, do you want to talk with her?
We can do that via the wizard, can't we?
It would be really convenient if we just spoke right here.
No, you know what? That's a video record of how he likes to co-parent. So we'll go ahead and just note that for the record. That's why we're all back where we're at. Have a wonderful day, Mr. Feindel.